Order. Welcome to the September Code Enforcement Board meeting. First matter is the minutes from last month's meeting. Everybody read them?
I had a change in the minutes.
Okay.
On page 4 of the minutes from last month, at the very top of page 4, Mr. Conlon, it says Mr. Richardson said that he hasn't seen this case come before this board. Well, that should read, Mr. Richardson said that he hasn't seen a similar case involving other property owners come before this board. It goes back to what was discussed at the bottom of page 3, where it said Mr. Richardson asked, how often does this occur with other property owners? Mr. McGarry said that code enforcement acts on a complaint basis. And going over it, it's not this case, but Mr. said that he hadn't seen a similar, or you could put the word similar or like their case, come involving other property owners come before this board, because as we know, there was another case involving the same brother. That's what if I did not say it that way, that's what was meant to be said.
Did you get all that? Mm-hmm. Okay. I need a motion to accept the. Do you have
Accept. Whatever you say.
second? Moving a second. All in favor? Aye. Motion carries. Any revisions to this month's agenda?
Yeah, I'll be pulling case number 3A for the citation appeal.
That's Thomas Middleton.
Correct.
Okay.
In addition, I'll be pulling CE.
Okay.
Do you want to state the reason?
I'm sorry, not CE. My apologies. Yes, I'll be pulling the Middleton case. He's going before the Planning and Zoning Board. He's going to try to resolve his problems that way. The other one I'm pulling is number 2, request for board order. D is in Delta. Matt Martise. He's complied.
And on mine, 13 CE 3984 is being pulled. We have notice to the bank. No, I'm sorry. We have notice to the servicer, but not from the bank. Item E, CE 13 CE 3925 is being pulled. Is that yours or mine? No, I'm sorry. Pull D, 13 CE 3985, 1835. Rewind. Can I start over?
Certainly.
Please do.
Too, when you
Sure.
call the numbers, it just helps us find
Yeah.
it.
Okay.
Yeah,
Don't worry about them. I'm caught up with you. But
All right.
he's smarter than we are.
Case 13 CE 3985, Jill Price, M&M Mortgage, is coming from a notice of assessment to a board order. The property's complied, but the fine has not been paid.
Okay, so that one,
So it's
you're not
Remove
pulling it,
that
you're
one.
moving it, correct?
Right.
okay.
But I am removing 13 CE 4024, Ute Ming Lee. There's the person who's paying the fine has been hospitalized, and I've given him until Monday, so I'm pulling him to try to work compliance before it goes to a hearing.
And what was the name?
Ute Ming
Oh,
Lee.
I see. Number E. Yep. Thank you.
Did you say you were removing or keeping 3985?
Let's be
3985 will
It's
go
moving.
as a board order. Complied but not paid.
And 3984 is still on, or
Is
Oh.
pulled because we have notice to the servicer but not to the bank.
good?
You were keeping up with me.
I was. I told you. Need a motion to accept the agenda as adopted or amended?
I'll make a motion to accept it.
I'll second. All in favor?
Aye.
Aye. Motion carries. Could everybody that wants to testify stand up and be sworn in, please?
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
All right. I assume we're starting with 13-CE-3770. John C. and Patricia Rapp.
This case came before the board last month for a board order, and we were going today for a notice of assessment. The gentleman here today represents the property preservation, and he'd like to offer testimony as to the status. The case was originally cited for overgrown grass and a non-op vehicle. The gentleman here today represents the property preservation, and they are trying to maintain a schedule of mowing the property. There is the car still on the property, and he will provide testimony as to what their time frame for that should be.
When was the initial complaint?
Okay,
410,
just for
13.
clarification, this is 13 CE 3770.
Yes.
John
Yes,
C. and Patricia Rapp and Champion Mortgage.
correct,
Okay. And this is an appeal of the issuance of the notice of assessment.
correct.
Okay. So what you're going into here is the timeline of the violation.
Right.
Okay.
The case was initiated on 410 based on a complaint of the overgrown grass. The property is a reverse mortgage foreclosure.
Okay.
Do you have any questions for the gentleman here today?
Well, is it in compliance?
The grass is being better maintained. There is a non-op vehicle, which he will provide testimony today that the bank's position is they don't have access to remove the vehicle until a final foreclosure.
And are you an owner, sir?
I am the operations manager for Ironclad Preservation. We do preservation work, which is the foreclosure. We maintain the foreclosure
Okay, so when a
properties all
property
through the
goes
state.
into foreclosure, you,
And Champion Mortgage is one of the companies that we do work for.
okay.
They asked me to. They sent a work order and asked me to appeal to attend the hearing today.
Can I ask that you state your name for the
Yeah,
record, please?
Tony Keck, K-E-C-K.
And tell us, would you, what is the reason you can't get to the car? Is that the problem? Or?
With foreclosures, there's two stages in the foreclosure process. With the reverse mortgages, they work a little quicker than a regular foreclosure, but a judge has to sign the final foreclosure papers before we're allowed to remove anything from the property. Once the notification of the foreclosure goes out, then we are allowed, the bank authorizes us to go out, change locks on one door so that we can provide access into the house to take the photos and document everything that's there, and then to maintain the yard. That's the only thing that we're allowed to do. We're not allowed to remove any debris or any vehicles being considered personal property. We're not allowed to remove personal property until the final foreclosure notice.
When do you anticipate that will be?
The reverse mortgage, it works quicker, but there are, it's backed up. The court systems are
Weeks,
clogged.
months, years?
We're probably talking a matter of the notice that came out for this is usually how, and that's part of the problem is that with the foreclosures, especially the reverses, if the bank's not notified that somebody's moved out, willfully give up the house, or they passed on, if they don't get that notification right away, the property sits unmaintained until a code violation notice gets sent to them, and then they issue a rush order, and we have to go out and try to get it into compliance.
Do you know, is this house occupied?
No, it's vacant.
The owners are deceased.
Oh, okay.
It's a reverse mortgage. They are deceased.
Is the car working?
Have no idea to find keys for that. Once the paperwork is signed, it'll be a matter of days. At that point, once the final foreclosure notice is signed, it would be a matter of days just to have it removed, and they would send us the work order. We would notify one of the local.
You've been maintaining the yard
Since Joe first got the work order. Once the Champion Mortgage was made aware that the former owners were deceased, they issued the work order to start maintaining the grass and to do a secondary door initial secure.
Is the car an eyesore in your?
Personally, I apologize, but personally, I have not seen the car. I do not. I do not know.
It's like an older four-door Buick. It has no tag on it. It's probably
Is it in a driveway? Is it
in a carport.
I just had a situation last week with two vehicles actually at a property that was in Sebastian, and we went out to do the initial property review. That was a final foreclosure. I called 2 days later. I had the work order to have the vehicles both removed. So it does work fast once the paperwork is signed, but it gets held up in the courts by the judge. And that's Champion Mortgage has no control over that. And us as their operators, we don't have any control over that neither.
And this would be tied up in probate as well if they're both deceased, right?
If there's family, surviving family, and there was an estate, it could be tied up in probate for a little bit. So that's hard to determine. With a reverse, it's a little easier to keep them out of probate because the reverse is pretty simple. They owned the house, they took the mortgage, the money out. There's only so much time frame that the family has to make arrangements to purchase the house back from the bank if they want.
I've actually tracked the daughter down through tax records and notified her and had no response. I don't believe she has any interest.
In a lot of cases, that's what we find. The families are they don't want to mess with it, or they have no means to deal with it. If they're out of state, they don't have any way to get down. They just whatever's there's there, and we haul away so much stuff that's. I've taken stuff out of houses. It's just unbelievable that people would leave, but.
The house is probably upside down of the mortgage versus the worth of the house right now also.
With that. And the values have decreased so bad that, they're not going to try to mess with it.
Mm-mm.
And like I said, I guess my question would be, is there any way that, because I can't get an honest time frame. I can't give you an honest time frame. I can research and see if I can find when the court hearing was set, if there's been an actual set for the foreclosure hearing. Once I know that, I could call back and allow somebody to know. But until that hearing's done and that final foreclosure notice is signed by a judge, there's really nothing that we can do, and there's nothing that Champion can do.
And do you have the lot on a regular schedule?
Yes,
every 2 weeks?
Mortgage companies will only authorize, cheap, they'll only authorize the grass to be maintained on a bi-weekly basis. The yard has been since, I believe it was July 1st when we first.
Now, are we due to be mowed soon?
It's due to be mowed today, as a matter of fact. I was driving down and called. I had a crew down here yesterday, and I have 2 crews down here today.
Yeah, because I was there yesterday.
Yeah,
it's at our limit.
It's actually due to be done today, but bi-weekly basis is the best we can do. They will not pay us to do it anymore, and
we're at the end of summer, so it should.
And that's true too. So it is starting to.
Thank you.
Okay. Do you have a recommendation?
No.
No.
Well, I move that we give it an extension for a month and ask that Mr. Tony, I didn't catch your last name.
Keck, I'm sorry.
Uses that month to try to research what you can on the foreclosure in the car, and the code enforcement office tries to see if they can locate the family again. The car's in a carport. It's not blocking a road. The lawn's being mowed, and I think the family at this point. I'm sorry, I didn't mean to interrupt. I think more time will let the situation help correct itself.
You think a month is enough?
A month, and then we'll review.
I think a month's enough time.
I can get with my people at Champion. I will get with them this afternoon. And once I leave here, I'll get with them and see if I can get some information. As soon as they can give me the information as to, a hearing date for the final foreclosure notice, that would give me once I know that date, then I can give you a definitive time frame on when it can be removed. But I can't, to have a junkyard come out and haul the car off, I can't legally sign the paperwork until I get that work order from the bank. Once I get that, I can legally sign it. And
we're still doing the $50 a day.
Yeah, we still have a fine running too. Right?
Oh, I would ask that the fine be suspended.
What we've done in the past is after everything's resolved, they can come forward and ask for a reduction, and Tim has a formula.
Okay.
That's what we've done with other cases that are similar to this, that the fines are running, and then when it's foreclosed or the property sells.
Okay, and then if they
What are the fines up to now?
Don't know.
Melody, you need to talk into your microphone too.
I don't know
please.
what the fines are.
I did have a similar situation 2 weeks ago in Lady Lake, and I was fortunate enough that they were willing to. They put the fines on hold for 6 months to ensure that the property was kept under compliance for that 6 months, and then if after 6 months, if it was still in compliance for that whole period, then they would waive the fines for the bank. I mean, they're kind of in a stuck situation. There's really nothing they can do, and.
Yeah, as long as somebody's taking care of it, I think.
Well, I mean, as long as then the yard is being maintained, and it will be maintained on a biweekly basis. Like I said, but the vehicle, that's a situation that they can't control. There's nothing they can do about it. I can't legally go in there and yank the car out.
No.
On the notice of assessment, as of August 14th, the fine was at $1,800 plus the penalty and the enforcement costs. So, and then plus $50 a day up until today.
And ultimately, they'll find a way to take that out of our pocket, rather than, because they won't eat that. They'll pay it, and then they'll turn around and take it out of us, and they'll try to figure out a way to make it our fault. That's just, I've been doing this for 15 years, and that's the way the banks operate. It's just
Not surprising.
no, it's not. But that's.
I think the 30 days is a bit optimistic.
Yeah, I do too. I would like to amend that to 90 days. And I don't know what to think about the fine, because it is in a carport. And if it were in an enclosed garage, it wouldn't be a problem. But because it's in a carport, it breaks the code.
Would it satisfy part of the? And I'm not sure. Would it satisfy it if we were to cover the car?
Yes.
Say put a tarp over it, and I mean that I can probably manage to swing that if it's the fact that it's sitting there with
bring it into
the
compliance.
rear end facing out with no tag on
Not
it.
really.
Well, certainly, this gentleman's doing everything his company can do. So, I mean, you could consider, since the property is otherwise being maintained now,
Yeah.
right?
Yes.
And if this
You
came from
could
a
put
carport-
you could theoretically hold the. I mean, if you want to continue the enforcement action on the vehicle, I mean, the board, you could still hold the continuing penalties in abeyance if you are so choose, and let him report back in 90 days or sooner if he gets a resolution.
As soon as I know something, I can call. Somebody let me know who to call, and I can call and let them know what's going on.
Liz, could we possibly just put that on hold for 60 days?
He is speaking.
90 days, I agree with them.
I said 60.
60? Oh, rather than 90?
Yeah, that's a long time.
Okay.
Is there any chance of vandalism? And I don't know
Okay,
exactly
is that
what his
all right with you?
address is.
I'm not sure.
Is that
It's on
okay
State
with
Road
you?
60, just
Okay.
over 6th Avenue.
I'm not the boss.
And this is one of those situations where he's accurate in that the bank is not going to remove any personal property. And I believe the record was checked and there is no probate case opened on these individuals. So there's not even a court to go to get a court order to say, yes, you can remove the vehicle. So in that regard, he's right. There's really just nobody to authorize removing the vehicle yet.
Right.
So
we're
Okay, so.
getting a status update in 60 days and putting the fines on hold. Is that right?
Boshi, do you want to add that to your motion? Because you didn't.
Yes, I do. Give us a status report in 60 days and hold the fine. What do you call it? Abeyance? Is that the right word?
that'll work.
Starting, is there a set date, Wayne?
What was the date the grass came into?
July 1st.
July 1st
That was the day. That was the day that I
when
did it.
was
We had people
the yard
come
was
to us.
brought into compliance. I mean, you could consider
To Scott, yes.
it's up to the board.
Correct.
If that's the day the yard came into compliance, I would say that it came into compliance as far as the yard on July 1st. And that we'll continue the car violation for 60 days and hold the fines in abeyance.
I would greatly appreciate it. Save me a lot of headaches. And like I said, once the banks know, they do get on it and they do have the paperwork. It just, sometimes people move out of houses, and I've been to properties where the grass is 5 foot tall. It's out in the country and nobody knows, and they just move. And it takes, in some cases with a regular foreclosure, it takes 4 or 5 years for them to get the final paperwork done. And if they don't know anybody's not living there, they have no way of knowing to send somebody out. Once it goes into arrears, they send an inspector out, which is usually a real estate agent, and I'll leave that one alone. But
Be careful.
in a lot of cases,
out
they
with
don't even go to the properties. They just report it occupied and send it in and get their trip charge money out of it. So I go to properties and it's obvious nobody's been there for 3, 4, 5 years. Well, it was just reported occupied last week. How is that possible? So.
Well, there's a motion on the floor.
I'll second it. All in favor?
Aye.
Is anyone
Thank
opposed? Motion carries. Thanks a lot.
Sir, why don't you give the clerk your address? That way she can send you a notice of that next meeting.
Okay.
That'll be in about 60 days.
All right, that would be fine. It's 1060 East Industrial Drive. Oh, I'm sorry. 1060 East Industrial Drive, Suite P, Orange City, Florida. 32763.
386-774-0800.
Yes.
You died?
Can you repeat the zip code, please?
32763. I'm sorry.
Thank
Sorry,
you.
that's getting a phone number.
Bad multitasking today.
And if you
you.
hear from them, you can report to.
I'm actually going to
Melody.
walk outside and call them right now and see if I can find out some information.
Okay.
Because y'all
So
going
you
to be
can
here for a
report it
little
to
bit.
Melody.
I assume.
If you hurry.
I'll see what I can do. I don't know if I can get a hold of anybody now. But
All right. Thanks. Okay. Case 13-CE-4007. Edward Fielkowski.
Do we want to see who's in the audience?
Oh.
What case they're here for?
I'm sorry. Sir, are you here for?
Are you here for a case?
No, I'm here to watch.
Okay.
Oh, okay.
This request for a notice of assessment for case 13-CE-4007. Violator is Edward J. Fialkowski Jr. was cited for weeds, grass, or undergrowth at a height of more than 12 inches at 703 Holly Road. Service of the citation was provided by posting the property and is on file with the city clerk's office. No request for a hearing on the citation has been received, so a hearing to contest the citation has been waived and the violation is deemed admitted by the violator. The violation has not been corrected as of September 10th. The property owner is a repeat violator. Civil penalty of $100 was assessed on the citation and has not been paid. Enforcement costs of $38.16 are requested by the city. An affidavit of those costs is filed with the board clerk. We request the board authorize issuance of a notice of assessment in this case, plus the enforcement cost of $38.16.
When was the first?
Is the house occupied?
Yes. When was the first one? It went to code board last year with Officer Keiki. August of last year. It went for the same
ago?
violation.
A year ago?
Yes.
Is it possible that the homeowner has been sick or out of the house?
We have another case
I
that we're
just
going
wondered
for a
with it
board order
being
on
repeat.
today. This property owner has been noticed for a stagnant pool. We're not getting
Yeah, I
any
saw
response.
the stagnant pool, and I just wondered. That's why I wondered if he was still.
He is, yeah, he works downtown.
So what do we do to get him?
Have you talked to him personally?
He does not respond to the posting of citations.
Are you just requesting the $100 civil penalty or continuing fines?
What did you say?
Your call.
What did you say?
The grass is still.
I asked if she's
right?
just requesting the
Okay.
one-time
Or have
penalty or
continuing
continuing fines.
penalties.
As a repeat offender, we can.
There are fines
pretty
running
hefty
now.
fines.
He doesn't take us seriously.
Well-
Obviously, he's laughing at us from a year.
Well, I think the fines are running from Officer Keiki's case at $50 a day.
So in this case, you want a notice of assessment of continuing penalties to be issued at $100 per day?
Are you saying after officer?
Yes.
It hasn't been cut in that whole time, or
No, it came into compliance, and then it came in again as a complaint now, which initiated a case. The neighbors are complaining. But though David's case complied, the fines were never paid.
the fines weren't paid? Okay.
Okay.
So that's all we can do is just keep the
Yeah,
clock going. We can't.
he's basically
Oh no, we can go up
ignoring
to
us. It
$500 a
sounds-
day.
Yeah, but if he's not responding, we can do $1,000 a day. It doesn't matter.
Eventually.
How do we get him to respond?
That's all we can
Matters
do.
in the end.
That's it.
Eventually, it'll catch up to him. Eventually,
Put in the
it'll catch
record
up
a
to him.
certified copy of the prior conviction.
Wayne, he can't sell this property without satisfying these things, can he?
Sell it all he wants, but it'll be sold subject to the liens.
Okay. Okay.
So there's nothing we can do at this point except keep the clock going.
No, we're
about it.
starting a different clock.
It's a
second
different clock. Yeah.
That's
Bigger
right.
clock.
The second time. That's right.
A more expensive clock. Does anyone have a motion? Jump at once.
Yeah, it would just be to issue a notice of assessment for the $100 per day, and plus the. Did you have enforcement costs?
Yeah, 3816.
Yes.
$38.16, and then the initial $100 also to be included.
It's $100 a day.
What is it?
Well, I'll make a motion that we issue a notice of assessment for the $100 civil penalty, the cost of prosecution of $38.16, and a recurring or a daily, what's it called?
Civil
A
penalty.
recurring penalty of $250 a day.
No,
Of what?
it'd be,
Can't do that?
no, you can only
As a
go to
repeat
100.
offender?
No,
Oh, let's do 1,000.
Did that change with the new rules?
you can't increase the fine other than what's on the citation. Only if it's
That did change with the
contested,
new
then it's
rules.
waived, and you can go to 500.
Okay.
Right.
Then we'll stick to the 100.
Okay, I'll second that.
Moved and seconded. All in favor? Aye.
Aye.
Motion carries.
I have a question. If this doesn't, nothing happens like next month, will this still be on here and then we're just another 30 days into it?
All right, we'll go for a notice of assessment next month.
Go for a final order.
The final,
Final order.
Brings us to case 13-CE-4067. Ron DeGrazia.
This request for notice of assessment for 13 CE 4067, violator is Ron A. DeGrazia, was cited for the violation of weeds, grass, or undergrowth at a height of more than 12 inches at 318 Conway. Service of the citation was provided by certified return receipt to the bank and posting of the property for the owner. No request for a hearing on the citation has been received, so a hearing to contest the citation has been waived and the violation is deemed admitted by the violator. The violation has not been corrected as of September 10th, 2013, and the civil penalty assessed on the citation has not been paid. Enforcement cost of $60.54 are requested by the city. We request the board authorize the issuance of a notice of assessment in this case plus the enforcement cost.
When was this first written, this complaint?
July 24th.
So it's not the whole property, just at the rear of the property?
Correct.
It's been ascertained that is not a right-of-way or anything like that?
It's the rear of the property. The home sits between two streets, and there's the back street property is not being maintained based on a complaint of the neighbors.
Then this is a $50 penalty.
Yes.
That's what's normal, is a $50 a day.
Yes.
All right, I'll make a motion that we issue a notice of assessment for the payment of the $50 civil penalty, the $50 a day recurring penalty, and the $60.54 cost of prosecution.
I'll second that.
Moved and seconded. All in favor?
Aye.
Motion carries. Alrighty. Case 13-CE-395. Jill Price.
We're requesting the board order on that one. The property is in compliance, fine not paid.
So that one you could just move down
Yeah.
to when you get to request for board order.
We're right there.
So is it just the $50 civil penalty?
We'd ask for enforcement costs when we get to that case.
We're at
Okay,
that case.
Are we at that case
You're
now?
moving it down now, or
We can do that now.
We just got there, yeah.
Okay.
When did you get in compliance? E is you, right?
We're not to the board order. Tom would like to do his case for a notice of assessment, 13 CE 3925.
Oh, sorry. I had that one crossed off, but then you rescinded it.
This is a request for a notice of assessment for case 13-CE-3925. The violator, HSBC Mortgage Services, was cited for a violation of overgrowth of weeds and grass in excess of 12 inches at 1445 20th Avenue, as provided in the backup materials. Service of the citation was provided by posting, and an affidavit is provided on file with the city clerk's office. No request for a hearing on the citation has been received, so a hearing to contest the citation has been waived, and the violation is deemed admitted by the violator. The citation has not been corrected as of September 10th, 2013, and the civil penalty assessed on the citation has not been paid. Enforcement costs of $38.80 are requested by the city. An affidavit of those itemized costs has been filed with the board clerk, and we request the backup materials be made part of the record. We request the board issue a notice of assessment of continuing penalties along with with an initial civil penalty of $50 and the cost of enforcement of $38.80.
When was the original complaint filed?
June 19th.
You've been in contact with him? Is he talking to you at all?
Yeah, we're starting to. But it's hard, though. It's a mortgage company, and I'm about 3 layers into a 10-layer system.
I see.
It takes a while.
Perseverance.
So what date would the continuing do?
Correction date on the citation was August 19th,
Right,
so they
yes.
would start August 20th.
The day after.
And what was the cost? The
$38.80.
$38.80.
Yeah. I'll make a motion then that we issue a notice of assessment with this $50 civil penalty and $50 continual penalty, starting as of August the 20th this year, 2013, and also the cost of $38.80.
I'll second that. Moved and seconded. All in favor?
Aye.
Anyone opposed? Motion carries. Okay, now we're to 13-CE-3985.
She's the one that's in compliance. She hasn't paid the fines, right?
Correct.
Right.
Where are the fines up to now?
Well, it came into compliance yesterday.
Okay.
But if there was no notice of assessment previously, it would just be the one fine, the one penalty on the citation.
$50 plus
$50.
enforcement cost of $58.61.
What was it again?
Enforcement cost are $58.61.
$58.61. Thank you.
And then how long do you give her to come up with that? It's $108.61.
They get 30 days from the date of the order.
And then what happens if they don't pay?
It gets recorded in the public records, becomes a lien.
So where are we there?
We need to issue a board order.
So we need to issue a board order for the 5861 and the $50 civil penalty.
Right. Order to be an order to pay.
Okay.
Right.
I'll say that. Like to say it again?
I'll second it.
Okay.
Moved and seconded. All in favor?
Aye.
Anyone opposed? Motion carries. Case 13-CE-3964. Alice.
No,
Beckler.
go back up, please,
Go
to
back up?
3789.
Oh, I'm sorry. Yep. 13-CE-3789. Edward Fielkowski.
This was heard last month for a stagnant swimming pool. There's been no contact with the owner. The pool is in the same condition, so we're asking for a board order for the $50 a day fine plus enforcement cost of $46.37.
And the chances of getting that along with the other one are,
This is the same gentleman that just ignores you.
right, 9
Right.
months twice.
Right, mail that goes
I
there.
just wonder if $50 is enough with that. I can't pronounce the word, but Dinjay, Ding Fever, whatever. We have like 2 counties below us in standing water. I take this even much more seriously than the grass, really.
Yeah. Especially on the
You're bound by the amount assessed on the citation.
Is that right? Okay.
Can't change.
Yeah,
the only time it can
Yes,
change,
you're
it's
right.
waived, and they come for a hearing in front of you
Okay.
for a contested hearing.
So what do you think we have to do to get this guy's attention?
Mail bounces back. He doesn't have a mail receptacle. I post notices on his front door and still don't get a response.
Does he live in the home?
He lives in the home and he has a business downtown.
Have you visited him at the business?
I have not.
You allowed to?
Might be considered harassment.
Yeah.
Really?
Yeah.
I go to his business. I
That's
don't
right.
think that I would. Cannot do that.
Is there any way we can make an order to do that to visit him, or is that too far?
I wouldn't go there.
Oh, thanks a lot.
That's the prosecutor's department.
Okay. Well, we just have no authority at all when it comes to enforcing anything, do we? I'm going to appeal to our mayor.
You hear the cases and you decide them.
Let's see how to word this.
So the most we can go is $50 a day?
That was the amount on the citation, it looks like, and that's what was assessed in the notice of assessment. So this would just be an order. If it's still not in compliance, it would be an order to correct the violation, continuing the ongoing daily civil penalty of $50 a day, and the order would also include the initial $50 penalty and the enforcement costs of $46.37, I believe it was.
Correct.
Okay.
Being this is a health issue, are we allowed to contact the health department to see if they can do anything?
Is his pool fenced or enclosed?
Screened.
It is enclosed, yeah.
It could be a health issue. Right?
Is concerning, yes.
Hmm?
It is of great concern, yes.
Are there any children living in that house? Do you know?
I do not know.
Got to be some way to get this guy's attention. What if some kid breaks in there and goes swimming at night and drowns, or
Like a drown, they'll float on top of the slime.
on top of the flies?
I'll make a motion that the board issue an order for correcting the stagnant swimming pool and payment of the $50 civil penalty and the recurring $50 a day fine and the cost of prosecution of $46.37.
I'll second.
Second, yeah.
Moved and seconded. All in favor?
Aye.
So
Motion
there's no
carries.
health issue we could go after on that, in the health department?
It's not really our call, I don't think. I think it would be the officer's call.
Private property.
Or bring
It's
it
a
to
health
the city
issue.
planner.
Oh,
Case 13-CE-4027, Jason Gaffey.
The violator, Jason Gaffey, was cited for a signed violation of the outside placement of banners for commercial purposes at 1146 21st Street. Service of the citation was provided by certified return receipt and posting the property. No request for a hearing on the citation has been received, so a hearing to contest the citation has been waived and the violation is deemed admitted by the violator. The violation has been corrected. The civil penalty on the citation has not been paid. Enforcement costs of $50.34 are requested by the city. Requesting a board authorize the issuance of a notice of assessment in this case plus the enforcement cost.
Well, I move that we find that the property is in compliance and that the civil penalty of $50 be charged, along with the cost to enforce of $50.34.
I'll second that. Moving and second. All in favor? Aye. Anyone opposed? Motion carries.
Just a question, when you send this out with the bill, $100.34, how long does he have to respond to that, 30 days?
30 days, right, Lee? When it goes out, they get 30 days to respond?
Yes. Well, when an order goes out, there's two deadlines, and they're all based on first of all, they have 30 days to appeal the order, and so we also give them 30 days by the code to pay. You don't want to force someone to pay before their time to appeal has run.
Did I skip something? Really? I thought we did. Thank you.
I could be wrong.
I'll check and see.
I'm holding it here to see why we missed it.
I think we might have. Thank you. Do you have any news for us? We'll squeeze you in here.
Appreciate that. Still got a lot of work to get done today. Third week of December is the hearing
Oy.
before title will be transferred over. I've talked with Champion, and I've got 3 possible ideas. I don't know which would fly. Tarping the car was one idea, if that would help. I don't know that that's going to work because it's going to be, it's still going to be an eyesore. The other possibility was possibly disabling the drive shaft and moving the car into the backyard, if that would ease the concerns. If not, my best case solution would be to go in and actually board up the carport, put a security door on it and board it up with plywood, and then paint to match the house so that it would look like an enclosure. The car would be out of sight, and we'd paint it up so that it would blend in with the house.
Who would pay for
That would be
that?
the best case scenario.
You would pay for that? to do
No, the
that?
bank's going to pay for that. They're trying to
But, I
they're
mean,
trying to
is
give
that
me
something
options
that
to
has
be able
permitted by the
to
building
satisfy the
department?
code and to help keep the fines off of them. They don't want to pay them fines, and I definitely don't want them trying to throw it on me. So
Well, the boarding up thing would probably have to be permitted through the building department to really do it as it should be.
And you're probably not allowed to get a building permit on somebody else's house.
Right. Well, that's
For
why
us to
it's kind
recommend
of like
that to
what I
you.
was looking at. It was kind of like when we go in and there's a broken window, we board up the window. I'm not trying to make a permanent structure there. I'm talking about using existing material there, throwing some sheets of plywood up around it to secure it, and painting it to match the house so that it wouldn't be standing out as an eyesore with with
Is
raw
the car
plywood
locked?
there. I don't know that neither. I'm actually going by that property on my way out here because I have
Because
to
if
go
it's
to.
parked in a carport and it's just sitting there, it doesn't
Right.
sound like that much of an eyesore.
Because the original
Not out in
complaint
the
was
middle
because
of
of the
the
grass. It
grass.
wasn't the car, right?
Well, like I said, whatever I need to do to try to satisfy this, because they're telling me that it's going to be the third week of December before they get their hearing.
Did it get called in as a neighbor complaint?
Several neighbor
Did
complaints.
they specifically complain about the car or the yard?
They complained about the yard, but we have to address every violation.
Right, of course, I understand. I'm just saying, if it wasn't in the carport, I think it
If we turn the
could
car
become
around
I-
so that the front end was facing out, would that satisfy the problem? Because
Well-
if it's
It'd
sitting
make it
there-
harder to see that it wasn't licensed, wouldn't it?
I mean, you wouldn't be able to drive by it and see
Make
that
sure
there
the
wasn't a
grass
tag
is
on
cut.
it, So, and it's not that much. I wouldn't
It's up
think
to
with the
you.
grass being maintained that it was that much of an eyesore. But like I said, I understand the code, the violation, the codes. I'm just trying to figure out, is there some kind of thing that we can come up with to satisfy everybody until they can get title, that we can get it moved out?
Wayne, is it possible just to put the car issue aside until the first of the year?
That's what I think. 'Cause
Yeah.
You really,
It's not the
you
issue.
already did that for
The
60
grass.
days, really.
Right.
Yeah.
We gave them 60 days, and we can
And
continue
you could
it again.
make another make another
60
motion
days.
and
Well,
lengthen
I
that.
think we
It's
should-
up to you.
I think we should leave the motion as it is, and in 60 days, if a neighbor has complained, or if the situation gets worse, then maybe address it. Personally.
Yeah.
I
I
second
played
that.
by ear too.
This is a main corridor of Vero Beach, so it is a.
Like I said, I haven't been to the
Do
property.
you have a
It's-
picture of it? Did you take a picture? Let's look at this car.
20th, because it's 20th place, 60 is 20th place here. It changes to 20th Street.
There's two halves of it right here.
Yeah.
So
Yeah,
So it
personally,
is on-
I don't
it is
see
on
that
60.
car as a eyesore to the
I'm
neighborhood or any
Yeah.
type of problem. It's a car sitting in a carport.
If y'all tell me what you want me to do to make everybody happy, I'll make sure that I can get it done. Outside of moving the car off the property, which I can't legally do. Anything else that I can do to satisfy this, that they're willing to authorize me to take care of.
I agree with Liz, as long as nobody complains about that, to leave the car issue alone till
Yeah,
the
just
bank
make
can
sure
make the
grass is
decision
cut.
to get rid of this.
I mean, it's not an old junk heap. It's not
No.
rusted out. The tires aren't flat. It's just a car sitting in a driveway, in a carport, in my opinion. It
Man.
would not disturb me as a neighbor.
Yeah. The people are deceased, right?
Yes.
Okay.
It wasn't intentional. It was just.
It's just they don't care.
Because there's a lot of people that leave their vehicle down
I don't
here.
think they have a problem with where it's at. So.
Any idea who removed the tag?
I have no idea. I'm sure if the tag, if there was a tag on it, it would have probably been expired.
Yeah, but no, obviously the tag's been removed.
And that's hard to say who would remove a tag. I mean, if it was still a valid tag, somebody riding around without a tag needs a tag. That yeah, because they see a lockbox on a door, or they see the grass going tall, they realize it's a foreclosure, and we have
Yeah,
break-ins all the
kids
time.
sometimes collect the tags, put them in their bedroom. But I think we beat this horse to death. Personally, I think.
Well, I don't mean to take up so much of your time. I'm just trying to see
No,
if there's
you're
some kind
very
of way
helpful. Thank you.
to resolve the
You're
issue.
very helpful. Thank you.
There's a lot of people that leave vehicles down here during the off-season and they put the hurricane shutters up, and it doesn't necessarily say that they've passed away. So I don't see it, just as long as the grass stays
Yeah,
cut.
see if like I said, I'm going by the property. I'm sorry.
It's not horrible. I think
We've
Mr.
seen way worse
Fiakowski's
than that.
problem is horrible. They go
if it
after
weren't so
him.
apparent that there wasn't a license plate on it, it might not violate
You
people's
can't put it in the
sense of
backyard. The neighbors will
order.
complain.
Oh, yeah, then you'd have to
That's-
cut the grass around it, so you might as well leave it where it is.
Like I said, just tell me what we can do to
Next.
keep everybody.
Did
You got
you-
it in advance.
Keep the
Did
grass.
you happen to check? If the car has a valid registration and some kid just maybe stole the tag?
I don't have authorization to go in the car.
Oh, you can't authorize it. You can't call motor vehicles and.
I can't identify the car.
Can't walk into the
You know when they
carport and
passed
get the
away?
ID number.
I'm sorry?
You know when they passed away?
Patricia passed away last summer. John passed away a couple years prior.
So it wouldn't.
Yeah,
Yeah,
it's
if it was
probably
last summer,
expired.
then obviously the tag would have expired by now.
Wouldn't
so.
have a current registration.
Right. I think just keep the grass cut.
I think someone will call you if it becomes a problem.
Okay. She's got.
The only thing is you might want to make sure
Too.
when you're on the property that it is locked so no kids could get in it.
Like I said, I'm going to stop by there on my way out, and I will verify. And if it's unlocked, I will lock it and secure it up. So
Just push it down the driveway when a truck's coming down.
Push it down the driveway till it's out in the middle of the street.
the thing with that is there's my guy get mad at me then because in December when the title gets to the property, I have to send my crew out to do the debris removal, and they have the work order to have the car towed. They actually call the tow company and the salvage yard to come out, and they'll actually pay them even without a title because they're signing the paperwork. They'll pay them for the car.
Oh, really?
So they get bonus money out of it.
So you just told me a way to get compliance.
Yeah, but you can't. You're not authorized to sign it because that has to go through the courts as well. So, yeah, but they got the two. There was two Volvos in Fellsmere yesterday, the day before yesterday, that they had towed out. They put $850 in their pocket as a bonus.
Good.
So
That's all right.
means I don't have to pay them as much.
To be clear, then, it's the board's position to just let the motion stand as it was. It'll be revisited in 60 days or roughly 2 months.
Just keep the grass trimmed, cut.
I'll make sure that's maintained. Like I said, it should be on the thing for today. And I'm going by there now to check and see if it hasn't. I actually have a mower. I'll go ahead and cut it today just to make sure.
All right, thanks for your
Thank
help.
you so much.
Can I clarify something, please?
Sure.
The last case you heard, I believe you read as 13 CE 4027. And the next case should have been 13 CE 3964.
You're right.
And I think that that's the case that Melody was reporting on.
Uh-oh.
Was Beckley the case that you just reported on?
That I
No,
was doing what?
we were talking about the sign violation. She did that right.
Well, they were both sign violations.
Oh, they are. They are.
Yeah, they're both.
Uh-oh.
For Gaffney, the cost of prosecution was $50.34.
That's
what
what
we
I've
had.
got.
Yeah.
Okay.
We just skipped this one.
So you just skipped Beckley?
Yep.
That's what I wanted to
We haven't
clarify.
I don't want to skip it. I want to hear it.
So we need to
Okay.
go to Beckley now.
We'll rewind. Case 13-CE-3964, Alice
Thank you, guys.
Beckley.
Alice Beckley and other occupants were cited for violation of house wholesale signs placed on right-of-ways after verbal and written warnings. Service of the citation was provided by first-class mail. It was provided on file with the city clerk's office. No request for a hearing on the citation has been received, so a hearing to contest the citation has been waived and the violation is deemed admitted by the violator. The violation has been corrected as of September 10th. The civil penalty has not been paid. Enforcement costs of $58.61 are requested by the city. An affidavit of those itemized costs has been filed with the board clerk. We request the backup materials be made part of the record and request the board authorize issuance of a notice of assessment in this case plus the enforcement cost of $58.51.
This Buena Vista, is that in a development?
McAnch Park?
Yeah. Is that 5851 or 5861?
Yeah.
5851.
Thank you. I thought she said 60.
This is for an order, not a notice of assessment.
Correct.
Okay.
Sorry.
And the fine was paid, I'm sorry.
Fine has not been
Not
paid.
been paid, okay.
So it'd be an order to pay the civil penalty of 50 plus the cost of enforcement of 58.61.
But it is under compliance.
Now,
Okay, well, I would make a motion that we
Right.
find the property in compliance, and that we have a final order for the civil penalty of $50 plus the cost to enforce of $58.61.
51.
second it.
$58.61?
5-1.
5-1, $58.51.
58.5.
Okay, I'll second
I
that.
heard it wrong.
Okay.
I did too.
Moved and seconded. All
Trying
in
to get you
favor?
another dime.
Aye.
Aye. Anyone opposed? Motion carries. Thank you, Sherry. That was all of them. Does anybody have any other business?
What about Martise?
Right. In Middleton.
Middleton was removed.
This one was,
Martise was
Suspended.
pulled.
oh, it was?
I didn't do that
Sorry.
bad, did I?
Martise was pulled?
Matt Martise
Yes.
was pulled, and
And
item E, 13 CE 424 was also pulled.
Yeah, okay.
Lee. Okay.
Martise was pulled, and you say so was Middleton?
Yes. All right. Then we'll adjourn.
You have a workshop?
We have a workshop. You can be excused if you need to go to court.
Supposed to be in Judge Holly's court in about 6 minutes.
Oh,
you
you
do
better
now?
go.
My daughter.
You can make it. It's about 5 minutes away.
Okay.
It's up to you. We still have a
Also,
quorum.
okay.
We still have a quorum if you have to go.
How long is this going to take?
Go.
I ain't that fast.
I think you're familiar with our procedure.
I hope so. Let's screw them open here.
If you want to reconvene us for a workshop.
We have to do that all official. I thought
Oh
we
yeah,
moved
it's
down
still
there to
it's
the
still a
table.
public meeting.
Oh, is it? Oh, okay.
Keep going.
Yeah. Now you don't know how lucky you were, Dan. Well, then we'll call our workshop to order. Are you gonna trade us?
Well, I'll give you a little background. Sherry was asked to put this on the agenda regarding what the board says policies and procedures. Let me give you in a nutshell what this board is about. This board is not a P&Z board. This board is not the recreation board. This is this board. You act as judges. and that's your job. So, in a nutshell, what I gave you this morning, I forgot to include it with Sherry's backup. You start in our code of 2-104, where it establishes that the Code Enforcement Board is created pursuant to a certain authority, and it derives from the Florida Constitution, home rule power, derives from Chapter 162, Code Enforcement, the Florida statutes, and 166, also the Florida Home Rule Powers Act. The procedures and the duties of the board are set out strictly in the Code Enforcement Ordinance, which I did give you the relevant parts of that. You should have gotten that in your backup, where it talks about the Code Enforcement Board in Division 2, starting at Section 2-276 of the Code Board. It lists specific duties and powers of the board. The board shall have the duty and the power to hold hearings on a regular monthly basis as needed and upon the written call of the chairman, vice chairman in the chairman's absence, or at least 3 regular board members. The board can adopt rules for the conduct of hearings, which I think we've done with, as far as the quasi-judicial procedures. They're the same procedures that have been adopted by the city council and other boards that hold quasi-judicial hearings. For the conduct of quasi-judicial proceedings and due process, basically, the board specifies that the board serve as an impartial judge to hear and justly make final determination of matters within the board's jurisdiction and to issue appropriate orders as the circumstances and justice require. Also conduct evidentiary hearings on appeals to the board regarding issuance of code enforcement citations and regarding notices of assessment, and to continue the hearings from time to time as the board deems appropriate. The power to issue subpoena is somewhat questionable, but we've got it in there. There's really no enforcement mechanism if somebody doesn't abide by a subpoena issued by the board anyway. It just isn't covered by state law. You'd have to basically go to court and sue somebody and ask the court to enforce the subpoena.
So the subpoena is not something we could use for this one gentleman?
It's probably not going to get you anywhere. Like I said, there's no enforcement mechanism. This board really doesn't have, it's a quasi-judicial board. It doesn't have judicial powers, okay? And really a subpoena is a court order. Mm-hmm. So, I mean, the mechanisms we have in place, they may be slow in some instances where people don't respond, but ultimately they suffer because they're going to have liens on their property that they're going to have to deal with at some point. That's the enforcement mechanism that the legislature really has given to these kind of boards. Of course, take testimony under oath. You receive evidence. You can issue orders having the force of law when it has to do with correcting violations, when it has to do with paying fines. You have the authority and powers to make findings and determinations regarding whether a violation found by the board to exist constitutes a public nuisance and represents a threat to the public health, safety, and welfare. You can issue orders assessing and ordering the payment of civil penalties and costs. You retain jurisdiction over the proceedings and orders that have been issued until the time to appeal has run. That's the 30-day period I've spoken of before. In other words, any order you issued today, if within 30 days it comes back before you, you can amend that order. But once the time for appeal has run, you really lose that jurisdiction if it's a final order. And that's basically how it works with the court system, too. You actually have the authority to mitigate, compromise, settle, reduce, and waive civil penalties for good and reasonable cause shown as determined by the board in the interest of justice if the violator has corrected the violation and otherwise complied with the board's orders, even though the board order assessing the civil penalties has otherwise become final. In that case, you can make provision for reducing fines or forgiving certain amounts. You can't reduce costs that have been assessed because the city's entitled to recover those, but you can reduce penalties. However, if that order has been recorded in the public records, it has become a lien then basically a debt owed to the city, and only the city council can reduce those. And you may remember we looked at a proposed ordinance amendment some time back where the council had asked for a process to be adopted to provide for a way for people to ask the council to have maybe get a reduction in the outstanding penalties. And that was adopted, and there is a process in the code enforcement ordinance now for it to be processed through the clerk and the code enforcement department for a recommendation that goes to the council on whether or not something should be reduced or forgiven. And then finally, if the city council submits something to the board for consideration and making a recommendation, such as on the ordinance that we talked about, we can't ran it by this board since it involved your processes and what have you for your recommendation on adopting it. Something that keep in mind, there is a limitation on authority to individual board members, and that is that no board member has the authority to initiate or prosecute an enforcement action. You hear the cases, you're not the prosecutor. In other words, a board member who is a complainant or appears as a witness in a case or a proceeding before the board is disqualified to participate in that action. In other words, you can't sit on the board and be a witness. It'd be just like going to court and the judge is a witness against you and he's also going to hear the case. That doesn't work too good.
So how do we know if there's someone on the board that's in conflict with somebody that's got a case coming? I mean, is there any kind of
one of the things
we have?
It goes without saying you should annually probably come to our update after the annual city election where Peggy Line from my office typically will give a review of a lot of different things that have to do with being appointed as well as elected public official. And that would involve also conflicts. The biggest one is financial conflicts. In a nutshell, it's going a little bit beyond what I was going to talk about today, but if the state law says if you're at your board meeting, you have to vote. But there's an exception for a financial conflict. If you have a financial conflict, that is, if your vote will inure to your benefit, you're going to make some money or lose some money, or any of your relatives, the company you work for. There's a lot of different ins and outs to the regulation. If that comes into play in your circumstance, you have to declare a conflict, and you fill out a form with the clerk, and you can typically discuss a particular case, but you can't vote. It's just that it recuses you from voting, doesn't recuse you typically from discussing. So I don't know if that answered your question, but otherwise, really the only other time that we've seen there's no hard and fast rule, but the courts on one or two occasions have said someone's animus, their bad feelings towards someone in front of them, has been so strong and so pervasive that they should have disqualified themselves from participating in it. So in other words, if you had someone in front of you and they're your neighbor and you just really don't like your neighbor, or you really do like your neighbor, if you feel you can't be fair, then you should disqualify yourself from participating in that case. Because remember, there's two parties here. You've got the alleged violators before you, and you have the city. The city, as far as you're concerned, is just a party to the case. You're not here representing the city. You're kind of independent. You're supposed to be independent and make decisions based strictly on the evidence that you hear in front of you. You're not deciding for the city or against the city. You're deciding against two parties. The city happens to be one of those parties because they're bringing the case. So you kind of have to act independent. So you don't want to you not only don't want to trample on an alleged violator's due process rights, the city has due process rights too, and you don't want to trample on those. So you want to be fair to both sides. Typically, the way the code enforcement ordinance is set up, as you know, some time back we modified it from Chapter 162 procedures, and the city adopted its own procedures, which is really a citation process, whereby a violator, typically they're warned, and I think code enforcement tries to work with people just to get compliance, whether it's a one-time violation or a continuing violation. And you know the difference between a continuing and a non-continuing. A continuing is one that can be corrected. The high grass, you can mow the grass and fix it. The non-continuing is a one-time thing, like maybe a sign on the side of the road, but the officers picked up the sign, so the violation went away. But still they violated the code, so they could be cited for a civil penalty for having violated the code. And you see the process every time we meet. Once the citation's issued, the options are a violator can ask for a hearing. If they do, they go on the next board agenda for a contested hearing of the citation. If they don't appeal that and they just pay it, that's a conviction, just in a nutshell.
Is the conviction recorded anywhere?
It'd be in the records of the clerk showing that the fine was paid, and that's an automatic.
Is that a public
It means
record?
that they admitted it. Oh, yeah, absolutely. They're all public records. So a violation is automatically admitted if they pay the civil penalty. Now, if it's one that needed to be corrected and they paid it, but they didn't correct it, well, you're going to end up seeing it through the officer asking for a notice of assessment. And the notice of assessment is just the notice that the clerk sends that the board has authorized saying, you have not corrected this violation as of this date. You've got a continuing penalty that's being assessed against you because you haven't corrected the violation. Now, if they correct it but they don't pay, it'd be like one or two you did today. It's just an order to pay the civil penalty because they've corrected it. If they don't pay or correct, you have that then that goes to the notice of assessment. If the notice of assessment does not get their attention, then it comes back that next meeting for the board to issue an order. And that order goes out to them. As with any order, they can appeal it within 30 days. And just to back up a minute, notice a citation or a notice of assessment, they can appeal. They have 10 days from the date it's issued, but you don't count weekends or holidays. The orders that the board issue can be appealed to the circuit court. They have 30 days from the date they're signed. But as we went through in the one contested hearing we had recently, the code strictly sets out what the board's determination is. The board determines whether or not there was a violation, and then whether or not the person that was named in the citation was responsible for the violation. Civil penalties are set out pretty much. What was done, we followed the criteria that some other jurisdictions followed, where basically it's a maximum of $500 civil penalty for pretty much everything, unless there's a specific section of the code that gives a different amount as a civil penalty, then that's the one that would apply. But what happens is if a person does not contest, then they have the benefit of a reduced penalty, which is for a first violation is $50. A first repeat within 5 years is $100, and these can also be continuing if they don't correct violations. Second or repeat within 5 years is $150, and a third or subsequent within 5 years is $250. So basically, that's why I say unless someone comes in front of the board and is contesting the citation, you're pretty much locked into what was cited on the citation. There's really no way to go above and beyond that other than enforcement costs or the continuing penalty, of course, for a continuing violation.
So the maximum fine we could, just as an example, this gentleman with the pool and the grass and all like that, the maximum we could ever get out of him is $500 for each complaint if we ever find him?
Well, he was cited, and he's deemed as having admitted the violations because he never contested.
Well,
so he basically has been found in violation simply by not responding once it comes to the board for any of the other processes. And no, he's going to be stuck with you're stuck with only assessing. But now the next time, if it's ever corrected, and he comes back before you, and it's within the 5-year period, it can be assessed at a higher amount.
But it's at $50 a day, just
It's still continuing to run.
on
Sure.
and on.
So there's not the max of $500. I mean, it goes
No.
$50 a day.
That's per day. That's per day, right?
Well, the reason it concerns me about the pool is, I mean, we had a child drown here not too long ago because it fell in a pool that was not guarded or whatever, the situation. I mean, that pools scare me, especially with kids. So I asked if there was any kids living there. That's a bigger fine than anybody wants to pay.
Right.
Fines just don't do a whole lot for some people. They just don't seem to care. But other than that, there was some other materials given to you about sunshine law, public records, Commission on Ethics, and that goes into voting conflicts, the quasi-judicial procedures. And this board is actually, we've been pretty lucky. There's been very few instances where the cases have been contested. Typically, the officers are really good at getting compliance and working with people. And typically, it's a case of people that just don't respond is the ones that is the reason you do get the work that you are getting for the notices of assessment and the continuing orders. So, but if you have any other questions,
I do.
Okay.
I was concerned about the cost of all of this. Like if you were to take one man with the grass, and by the time the officers have gone out there several times and all like that, it becomes very expensive then to get only $50 in a fine and $43 or whatever. Is it in a day when we're trying to save money? I mean, is there any other way to put more teeth in any of this or speed it up or whatever?
Well, I mean, the officers request for the city, on behalf of the city, whatever they feel their costs have been, and they are limited to actual costs incurred.
Right.
You can't just pull a number out of the air.
No, I have the figures here. That's why. Yeah.
And they do. They fill out an affidavit as to
Right,
what the
I have
costs
it.
were, and that's why they ask for those costs. Now, as far as the civil penalties, they could be modified by the city council. That would take an ordinance to modify the code. They could increase the amounts of those civil penalties. That's just the $50, and it used to be a $50, $100, $150. It was even a slower progression than what we have now.
When was the last time it was increased?
Oh, probably when we modified it to put in the. No, it was when we added the process for asking the council for a reduction. We increased them at that time. So that was, I think, maybe earlier this year or the end of last year.
Oh, so there has been
The 50 hasn't increased. That's been the same for many years. But the elevated penalties after the first violation, those were bumped up some.
this year.
And one thing to keep in mind, unless you read through the code, you don't realize that on repeat penalties, actually there's a provision that on a repeat violation, the subsequent days of violation, the penalty is doubled.
Is what?
It's doubled.
Nice.
So we may have to look at that one we did today that was a repeat. That may have actually gone to 200 per day.
And then if there was anything that could be done to get more teeth into this, for this gentleman particularly, Would that have to be something that has to go to the city council for approval, or how does that would just?
Well, you don't make changes to the code just for one. Obviously.
No, I know.
It's for across the board.
Right, exactly.
Right, and the city council would have to adopt an ordinance and amend the code enforcement part of the code to change those penalty amounts.
Because I got an affidavit from the code and enforcement, and the amount for what it takes and costs for us to go and do this, put the notice on the door, that sort of thing. This doesn't even include the work that the clerk's office does, which is another lot of money, and it concerns me that I talked to a gentleman this week. This is what's triggered it. And he owns some property around where I live. And he said, I asked him, I said, how often do you cut the grass? He has an empty lot. Only when code enforcement gets a hold of me. So he's living on the edge. He would rather, because he knows that, what are we going to do? It's going to take 9 months for us to ever get to a point where we do anything. That was what brought this all about, because I think he's probably the only one on the whole street that does not cut the grass until somebody knocks on his door. And I'm sick of it. I don't know about anybody else, but if there were more teeth to what we do, I mean, not discounting what you guys do, but it's very not cost effective. You see what I'm saying? Did I confuse you? With going after them and making them comply faster if it was costing more. I don't know.
Yeah.
It's hard to change people's behavior.
Oh, I know.
You should have been here before we opted out of Chapter 162. It took even twice as long to get things taken care of. Yeah, that's why we used. We went to the citation process, and it sped it up quite a bit, I believe, from what we used to have, because the 162 process, you basically in every single case you notice the person to appear, and you couldn't even really find them until they came to the board at least twice.
Oh, wow.
Yeah, they had to come to the board. The board was obligated to give them more time to correct. And it was even a more long, drawn-out affair, trust me.
I just thought in the view of everybody trying to cut back on money and expenditures, this would be a twofold possible solution. So,
well, like I said, the code enforcement was definitely entitled to request whatever they've expended. When you have a contested hearing, the board can impose costs of the hearing, which would be the clerk's time, the facility. But again, it would have to be calculated and computed probably by the clerk to see what the cost for having the hearing was, and that could be imposed as part of the order if a person's found in violation in one of those cases. And again, typically, even if you have a continuing violation, the board is going to pretty much always be inclined to give the person. In fact, I'd have to pull it up. I believe even if you do find a violation after a contested hearing, the process is you then give them a reasonable amount of time to make a correction of the violation. We have had so very few of them since we first implemented this about 4 years ago, I think. Yeah. Let's see. Yeah, I don't have that added in there, but it's similar to 162 in that respect, where if the board finds the violation, you're still obligated to give them a reasonable amount of time to make the correction. That's in a contested case. Liz, what's your questions?
I have none.
Oh.
I just asked her how long I've been on this board.
Oh.
Since 2001.
Well, you get your gold watch soon.
Wait, that's what I'm banking on.
Anything else?
I think
think so.
the new way goes quicker. It's pretty cut and dry. You either
Yeah.
paid it or you didn't. It's either
To the
cleaned up
corrector,
or
is
it's not.
right? Exactly.
It's not as much fun as the old way.
Not so much fun.
Using fun in a lighthearted way. I mean, we used to see.
Well, you had a lot more
pictures and
people in front of you.
Well, a case was presented, and you got a lot more of kind of the little nitty gritty, and you felt like you had a little more to judge on. Whereas
here
now
for
it's
hours.
pretty cut and dry. It's streamlined.
Tom, you or Melody have anything?
I've worked under 162, and though you do present the whole case and have that, you have the same problem like you do under the citation.
Yeah.
Right before the hearing, they comply. You can't get a repeat violator status because they're in compliance. So I prefer the citation process.
Oh yeah, I prefer this process, but the other
Yeah, and
one
the-
was interesting.
The situation you're talking about, the gentleman that won't cut his grass unless what needs to be done there in a case like that, if the code officer goes ahead and actually writes him a citation and he either pays it or there's an order entered finding that there was a violation after a hearing, then the next time it's going to be the higher penalty, and then the next time it's going to be it's going to get so expensive for him that he'll probably cut the grass.
But I mean, if he complies right before the time limit, he does it right on the edge.
Yeah.
Every time, but then in the rest of the time, he lets it go. So
Well, they can issue a citation, and I'm sure they do this. They'll warn people and give them a chance to correct it, and right on the cusp, they'll fix it. But then when they do it again, they'll cite them, but issue a civil penalty. And once there's a civil penalty issued, that then will become a repeat violation for the next time. So you can't just keep giving them warnings. Yeah.
Right.
A lot of times we'll start out with a courtesy letter saying, hey, this is the code, don't know if you're breaking it, but you are, this is what you need to do. I mean, most of our goal is compliance through education. You're going to have people that wait for...
Live on the edge, right.
Who don't have the grass or something. We're limited with those people, what we can do.
Mm-hmm.
Bottom line, we get compliance, that's what we want.
Right.
So if they play the system to their advantage, but they're trying to get compliance, the whole goal of code enforcement is compliance.
We're not here to collect money.
What?
So we're not here to collect money.
Oh, compliance.
Did you run out of tape? Oh. Shame on you.
My bad. Did you hear that? My bad.
Are we good?
We're good.
That's all I had.
Thank you.
Okay.
Thank you.
See you
Thank
next
you.
time.